Why don't we open the meeting? This is the regular meeting of the DuPage County Ethics Commission for October 12th, 2022. If I could have the roll call made, please.
Member Demling. Member Demling.
Here.
Member Benson. Member Cahalan. Member Clement.
Here.
Member Donner.
We have a quorum. The next item is the chairman's remarks. There really hasn't been anything happening since our last meeting. I have nothing really to report. One thing, however, maybe for the new members, we're going to talk later on about the ethics training, which is something that we all have to take. In addition, we don't meet again until next February. Sometime, I think towards the end of February is when the the statement of economic interest come out. I don't know if the new members have yet had an opportunity to fill that out. If they haven't, it's just a reminder that that's due, I think sometime in
I believe
April.
it's, yeah, I was going to say, I believe it's the beginning of April.
They generally send it out mid-February. If you're not familiar with it, you can call one of the staff members. They're actually have become much easier to fill out because you can now do it all online. And I think they have a record of your last year's one that you just reviewed. So just a reminder to the newer members again, I wasn't sure whether you all had an opportunity to fill one out. At this point in time, is there any public comment? Hearing none, I'd ask if the members had an opportunity to review the minutes of the past meeting. And if they had, could I have a motion? First of all, any comments or corrections to the meeting, to the minutes of the last meeting? Hearing none, could I have a motion for approval?
Make a motion to approve.
Second, Clement.
All in favor, please say aye.
Aye.
All opposed? The ayes have it. The next member is old business at this point in time. I'm sorry. Oh, the other action items. We have the 2023 meeting schedules. I don't know if each of you have had an opportunity to review that. I think those schedules are February 1st, June 7th, and October 4th of 2023. At this point in time, is there any issue with those dates with the commission members?
Oh, it's that one. I recall at our last meeting that our ethics advisor was never available on the first Wednesday of the month, which is why this meeting and last meeting was scheduled on the second Wednesday of the month.
Okay, well, no. And no, actually, I think it's probably easier for the ethics advisor just advised that he has a conflict on the first Monday of each month. Frankly, it's probably easier for us to reschedule our meeting than it is for him to try to reschedule something he has in a professional matter. And so it probably is best then to do this the second Monday of each month of those months, unless there's an objection or concern that any of the board members have.
I just thought it would be easier to do it now than.
Absolutely, and good catch on top of it. So why don't we change that to the second Mondays of each of those months? Wednesdays, I'm sorry.
Council, are we going to have to take a motion to amend on this?
Yes.
Okay. If I could have Chairperson Cahalan make a motion, since it was your catch on this thing, if you would just.
I'd like to make a motion to amend the previous motion that our meetings for 2023 be held on the second Wednesday of the appropriate months.
Is there a second to that?
I'll second that motion.
Second, any further discussion on that? Again, good catch on that one. Thank you. All in favor, please signify by saying aye.
Aye.
All opposed? All right, now, just for purposes of the record, I gotta run to my calendar. So I know what the
Chairman, I have the dates for you.
Yeah, second Monday of February, it would be February 8th.
I have,
June,
Chairman,
yes,
I have February 8th, June 14th, and October 11th.
all righty.
October 11th.
All right, so the record will reflect that our meetings for the the 2023 meeting schedule will be February 8th, 2023, June 14th, 2023, and October 11th, 2023.
Just a comment there.
Yes,
On June 14th, make sure you bring your flag because it is Flag Day.
Flag Day. And actually, it's, well, I won't say, as a result of some events, I've been cleaning out my house and I found several old flags. And I was trying to figure out how you dispose of them. And a friend of mine indicated that police departments provide for disposal, proper disposal of old flags. I'm sure you mentioned that.
Some of the veterans halls, I know in Elmhurst, you can take it to the veterans and they have it also there.
Oh, is that right?
Oh,
Yeah, yeah, well, and it was something that just out of curiosity, you know, I had 46 years of living in a house and a lot of stuff you accumulate. That happened to be one of them. Well, anyway, thank you. The next item, old business, tabletop exercise for the mock trial presentation.
I'll let Greg take over from here.
Yeah.
thank you very much.
And just for purposes of the record, could you just introduce yourself? Sure.
Gregory Vacy, VACI. I'm the Investigator General for the Ethics Commission. No, I have some copies. Thanks. So we're going to put on this little exercise. I'm going to prosecute what is a case alleging violations of the ethics ordinance. For this case, Lisa's going to be the respondent's attorney. So we're not gonna get too far into the weeds here, but I think it's a good exercise so you can kind of see how these types of administrative hearings typically go. I'm not a huge fan of the mock trial because, you know, they're kind of, it's a little more show than anything else. But this was a problem that was used before Paul Mareschi when he was the Investigator General. He put this together. So rather than reinvent the wheel, we're going to use this. Yeah, that's fine. So I'll give you a little opening statement so you can kind of see what this case is about. I don't think any of you have seen those documents, correct? Okay, so those are like exhibits. Well, not like, they are exhibits that typically would be used. In most cases, they're agreed upon before the hearing. So you would have those in front of you. If they weren't agreed upon, then they would have to be admitted into evidence after somebody, you know, testified regarding them. So this case is going to consist of 2 witnesses. We're sticking with the names that are on the document. So Camille, complainant, is the person who made the complaint in this case. She's an employee of the county, and she was making the complaint regarding her supervisor, who is Richard Respondent, played by Dan Hamlin, soon to be. So the way the process works is a complaint is made, a complaint was made in this case. The Investigator General then contacted the complainant and contacted the respondent and the person in the county that supervises the respondent. And the respondent then is advised of his rights. And he doesn't have to respond to the complaint. He can respond to the complaint in writing if he chooses. So that's what we have in this case. One of the exhibits, I think it's exhibit 2, is the response by the, no, I'm sorry, it's 3. 2 is the rights that he signed off on. So in this case, based on what the complainant the allegations made by the complainant and the response by the respondent, which when you read it, you'll see that he is essentially admitted to most of the facts. So there's really not a huge factual dispute in this case. So the issues are going to be kind of in the margins here. So first allegation is an allegation that the gift ban section is violated. That is section 2473. And there's certain elements that have to be proven in order for you to find the violation of the gift ban. The first, of course, being that the commission has jurisdiction over the people and the issues in this case. Okay, so for purposes of this mock hearing, the commission does have jurisdiction. I'm not going to get into that too much with the witnesses. I may ask them a question, but typically would not be here if jurisdiction was an issue. So Mr. Respondent is a procurement officer. He acts as a procurement officer, operations officer for a Department A of the county. Under the gift ban, the question essentially is, did he, the respondent, intentionally solicit or accept any gift? And then a gift is defined in the ordinance under 2-455N. Did he accept any gift from any prohibited source? And then prohibited source is also defined in the ordinance under 2455X, sections 1 through 6. And once those elements are proven, then the question is, was there an applicable exception under 2-474 or compliance with section B or C of 2-473A? So those are going to be the issues as far as the gift ban. After we're done with the witnesses, I'll explain why I think the ordinance was violated in the gift ban. And then the second allegation, 2-480A4, conflict of interest. In a nutshell, the question is under section B of that, did the respondent engage in an act that was a conflict of interest, which is kind of a definition, using the term to define itself. But a conflict of interest is essentially, you're attempting to serve two masters. You can't be an agent of the county and operate for the benefit of someone else to the detriment of the county. So that the conflict of interest is defined in 2-480A. We'll get to the exact definition. There's a section in 2-480 that says that receiving a gift for purposes of obtaining special consideration or influence is a violation of that section. So both of these sections are based on the gift that was given in this case. The conflict of interest then requires a little more proof of additional elements. So with that, I'm going to call a witness. It's Camille Complainant, who is the complainant in this case. We'll assume that she was sworn in. He or she was sworn in. Okay. Can you say your full name?
Yes, Camille Complainant.
And how old are you?
I'm 33 years old.
Are you currently a employee of the county?
Yes, sir.
How long have you been employed by the county?
Approximately 15 years.
Okay. On April 25th of 2014, Did I interview you? Do you recall that?
Yes,
Okay, did I ask you questions regarding a complaint that you made with the Ethics Commission?
yes, sir.
Um, are you familiar with Mr. Richard Respondent?
Yes, he's my supervisor.
Okay, and what is his position, if you know?
Operations manager for County Department A.
As operation manager for County Department A, does Mr. Respondent act as a procurement agent?
Yes, sir. He is the procurement agent for our department.
And what does that entail, if you know?
He's the individual that signs off on where we're purchasing supplies from.
Is that something you're personally aware of?
I'm aware that he's the one that does it. Yes.
Okay. Do you recall how long Mr. Respondent has been the procurement agent for County Department A?
Yeah, I believe he started with the county about 5 years ago.
And soon after he started with the county, do you become aware of any changes that he made with supply vendors for office supplies?
Yes, just a little bit after he was here, he did switch to vendor office supply company in Wheaton.
Does Department A, County Department A, have occasion to order large quantities of office supplies, if you know?
I would say it's consistent. Yeah, we consistently order supplies.
Can you tell the commissioners what you became aware of as far as the changes that were made?
Yeah, I had found out that upon switching vendors that my supervisor, Richard, he had known the individual who owns the vendor, what do we call this? Vendor, the vendor company, vendor office supply company. I was aware of that, and Richard or Vince from there had visited about 3 or 4 times a month and always stopped by. But again, that happened after Richard had started with us.
Can you call your attention to April 21st of 2014? Do you recall being at work that day?
I was at work that day.
Do you recall a conversation that you had with Mr. Respondent at the County Department A offices?
Yes, I did. That day, I think it was after Easter, right after Easter, that Richard had come in and he had mentioned that he was playing golf with Vince that weekend. And
Let me stop you for a second. Was anybody else present for that conversation?
I don't believe so.
Okay, continue.
But he had mentioned something about Vince Vendor. It took him to his country club to play golf that weekend, whatever that date might work out to be, and that they had lunch and drinks, and that he had indicated that Vince Vendor had paid for the day's activities. And then I had asked him, how often does that happen? And, he said that they've been doing it almost every Saturday last year, golfing as well.
Based on that conversation, what, if anything, did you do?
After finding that something just didn't seem right to me, so I filed the ethics complaint and submitted it to your office. And I believe that was a few days later.
When you say something didn't feel right, what was your concern at that time?
At that time, I was concerned at the fact that we had switched office supplies to this individual, and Vince had been coming around the office a lot, and it just didn't seem right for procurement purposes based off what I knew of how county procedures are and the ethics ordinance.
Was that that one day, April 21st, 2014, was that the only time you had a conversation with Mr. Respondent about that incident?
Specifically about that, yes.
You haven't had any conversations with him since then?
No,
He hasn't.
not about this matter, obviously,
About that.
for regular day-to-day work operations.
And on April 21st, that same day, you said you made a complaint to the Ethics Commission, is that correct?
Yes. And I believe you got back to me on the 23rd or 24th.
You were provided with notice that of your rights in this case, as far as having to testify or intending to testify, is that correct?
Yes, sir. You
were
gave me a
aware?
form and I believe I signed it.
Thank you. So at this point, then obviously he would be subject to she would be subject to cross-examination. So Lisa's gonna determine if there's.
Let me ask a question.
Sure.
In the event, this is a relatively straightforward case, but in the event that there are certain nuances, is it appropriate or is it for commission members asking questions?
Yes, it is. I was gonna bring that up. There's nothing precluding that in the ordinance. Procedurally from you asking any questions at any time. You know, so I would say probably the best.
You're good.
Okay.
Oh,
Michael, but
yeah.
more.
Okay.
I mean, I think probably the best way would be to funnel or address any questions to the chair. I would think that would be the best way. I mean, you could devise any way of doing it. I mean, even juries are asking
But
questions now.
In effect, at some point in time, they're going to be asked to be the sort of finders of fact.
Yeah,
And if they have any questions, they can certainly raise those either directly, and this would be something to be worked out ahead of time.
right.
Either directly or through the chairman or in some other fashion.
It could be done in writing, jot it down, hand it to the. You know, I think with all of that, become part of
Yeah,
And just to add to that, the rules of evidence don't apply to administrative proceedings. So it's not like a structured trial where hearsay, for example, can be admitted, whereas in a regular trial, you couldn't admit that without, or unless it was not objected to.
Yeah, and again, just so for the non-lawyers, there is some evidence that might come in, but the basis for it is sometimes questionable. That's why in a court, it wouldn't be allowed. It is allowed in an administrative hearing, but you're to weigh that based upon the fact that this may be something was heard by not just another party, but a third party or a fourth party. And those are the items that while it comes into evidence, you can hear it, you have to weigh that in your determination as to what is most credible, most more probably true than not true. And that's actually the standard. This is not a standard of beyond a reasonable doubt. It's,
Right.
It's what's more probably true than not true.
Right. And from my perspective, while it is specifically set out in the ordinance that hearsay is admissible, from my perspective, I would always try to eliminate or avoid, you know, the use of hearsay because, you know, theoretically, the person who's the respondent in this case could get anything from a reprimand, you know, to a termination. So you don't want to have those types of decisions that you're going to be making based on hearsay. You want to hear from the people, you want to hear from the horse's mouth, the people who are actually making the allegations. Therefore, you know, the respondent's attorney can cross-examine. You know, I think you get more of a legitimate result, the less hearsay you have. But obviously it's, you know, it's like Dan said, it's not the same standard that a court would have.
I'd like to just interject a question. Let's say a determination is made by our commission. And the party who doesn't come out on the winning end is unhappy, of course. Can they then file something in circuit court?
I'm not sure if we're subject to the Administrative Review Act or not.
I'm almost certain it is, especially if this recommendation is termination, but I believe you would have the right to go in and appeal to the
Oh.
circuit court.
But
It's an
would it be an
administrative review.
appeal? Would it be an appeal of the administrative decision?
In event, what happens in a review there is a statute called the Administrative Review Act. And that statutes allow determinations by review agencies such as ours to be reviewed by a court. That court doesn't have a whole new hearing. It simply relies upon the record that occurred in the administrative review. And what will happen is there are always, it is either recorded or transcribed. The best, well, I'm old fashioned. In my view, the best way to do it is to have it transcribed. And I'm sure we would have this transcribed. That transcription and the minutes from the meeting would then go to a circuit court judge. That judge would then determine, based upon the record, not any new evidence, but based upon that record, whether the determination fell within the criteria of the statute. So the answer is it is in effect an appeal, but it's not a new hearing. They have to base it. That's why it's so important for us to lay the appropriate foundation for any decision that we make, because it will be that foundation and that record that the courts rely on. Yeah, once a circuit judge makes a determination, that determination can then be appealed to the appellate court as well. And again, the appellate court is basing its review only on the record that occurred at the administrative hearing before us. That's pretty accurate.
It is, and the ordinance does specifically provide that we are subject to the Administrative Review Act, it's the state statute. So it does go to the circuit court if the individual need.
If there, yeah, just to put a bow on it, so it's actually on the last page of the under part 6, administrative review. Decision of the commission to dismiss a complaint is not subject to administrative review under the Illinois Code of Civil Procedure. So if the county loses, they can't go to administrative review. If the commission's imposition of any penalty, fine, or sanction is the final decision and subject to administrative review pursuant to the Illinois Code of Civil Procedure. So if somebody gets even a reprimand, according to this, which would be some form of sanction, typically, administrative review is going to cost a lot of money and take a lot of time. So those don't happen unless somebody loses their job or gets a significant suspension. So, okay, so where we left off. Okay, so then that would
Thank you,
basically
Lisa.
be it. You'd have the one witness, and again, however the commission decides it wants to address you asking questions, because that's obviously, you're going to make the decision. So any question you have in your head should be asked of the witness at the time, because it's the only time once he or she gets off of that witness stand, all you're going to have is the record. So with that, I'm going to call Dan's going to be Richard respondent. You have all the exhibits, Dan? No.
I don't.
Yeah.
Here, I got him.
So this is, again, this isn't a criminal case, so we can call the respondent. He has all his civil rights under the 5th Amendment. He can decide, if an attorney's telling him he shouldn't answer a question, he can always take the 5th. We're not going to obviously deal with those issues here, but if anybody had any questions about actually calling somebody who's being accused.
Let me ask you one question. Since this is a civil and not a criminal matter, if somebody does take the 5th Amendment, can we construe that fact against them?
Under the Illinois, yeah, I would assume you can't.
I would think you can.
The ordinance doesn't.
Just for, again, non-lawyers, the 5th Amendment applies to criminal matters. Now, if you are in a civil case, you can take the 5th Amendment. However, in a civil case, the trier of fact, a judge, for instance, can construe that negatively against you. And these are not criminal matters. So I've never seen it in a public case, but again, it's an interesting question that comes up from time to time.
And also, since I'm calling him, he's really kind of an adverse witness to the county. I probably would ask him, more leading questions. Typically, then just like I did with the complainant. Because the complainant, you want to hear their story from their own words. So just so you know that. Can you state your full name?
Richard respondent.
And you've been sworn in, is that right?
Yes.
Who are you employed by?
The County of DuPage, the Department. County Department A,
And how long have you been employed there?
approximately 5 years.
Calling your attention to April of 2014, were you contacted by myself?
I was.
And did I inform you that a complaint had been filed against you?
You did, and I was shocked and appalled.
Once you gathered yourself, did I inform you that you had certain rights with respect to the ethics ordinance?
You did.
And did I provide you a written document, a printed document regarding those rights?
I don't recall. I think you did. I do remember you giving me something. to
Take a
sign.
look at Exhibit 2 that you have there.
I do. I have that in front of me.
Is that the document I provided you?
That does look like the document.
Is that your signature?
Does appear to be my signature.
Did you have, at that time that you signed it, did you have counsel?
At that time, I don't believe I had retained an attorney.
Was there anything about this document that you didn't understand when you signed it?
No, I believe I understood it.
Okay, and after you signed that document, did you respond to the allegations that I informed you of?
I did.
And is that exhibit what you responded to in writing? Is that Exhibit 3 that's in front of you?
It is.
Is Exhibit 3, have you had a chance to look at it today?
I have.
Is it in the same condition? Has there been any changes made to it since you sent it in?
Well, I know I didn't have a receive stamp on it when I sent it in. And
Other than that-
the date wasn't circled.
Other than those two things?
Yes, it's in the same condition.
Since you authored this document, have there been any changes that you would like to make to it? Or is it still everything in the document accurate still?
I believe it's all still accurate.
So let me ask you, you understand what the allegations are against you?
Sort of, yeah.
Okay, so have you been provided with Exhibit 1, which is essentially the complaint in this case?
I have.
And you've had the opportunity to review it?
I have.
In 2009, did you become the operations manager for County Department A?
I believe it was in 2009, yes.
And you've been in that position continuously ever since?
Yes,
One of your duties or a portion of your duties, does it include procurement of goods and services for Department A?
it does.
When you first became employed in that capacity in 2009, did you make any changes with respect to vendors for office supplies?
I did.
What changes did you make?
Well, I thought the prices we were paying were way too high, so I asked my my longtime friend, Vinnie Vendor, to give me a bid for the supplies we ordinarily order. When I received the bid, it was below what we were paying. So I directed our department to start ordering those supplies from vendor supply company in Wheaton.
When you say that you believe that the prices were way too high, what did you base that?
Just having reviewed the office's budget and the previous procurements and things of that nature. Plus, I had a general idea of what office prices should be, and they just seem to be real high.
How long have you known Mr. Vendor?
I've known him since we were children. We used to play golf together, went to school together.
Did you contact, in addition to Mr. Vendor, with respect to the office supplies, did you contact anyone else? With
No,
respect to soliciting bids?
no, I don't believe I was required to. I think his prices were better, and I switched our purchasing over to him based on those
So the
prices.
answer is no, you did not contact anyone else.
I did not contact anyone else except for the prices we already had with the
Is there
office.
anything preventing you from contacting anyone else with respect to soliciting a bid?
I don't believe I was required to, but I don't think there's anything preventing me from doing so.
And that was in 2009, is that correct?
That sounds right.
Have you made between 2009 and currently? Strike that, between 2009 and 2014, were there ever any other changes made to procurement of office supplies?
No, we've been using vendor office supply company in Wheaton since that change.
Now, have you actively checked prices with respect to office supplies to see if you could determine that you could get any cheaper?
I haven't, but I don't believe I'm required to.
But so the answer is no, correct? You did not.
That's correct.
Now, in 2012, did you have occasion to golf with Mr. Bender?
I've played golf with Mr. Bender since we were kids.
And how often would you golf with him?
It depends how busy we both are, but as often as we can, as often as the wives allow it.
Okay, in 2014, 2012, which was 2 years ago, would I be correct that you golfed with Mr. Bender at that time?
I believe multiple times in 2012 I played golf.
Okay, were any of those times in a private country club where Mr. Bender was a member?
Yes, he joined a club, and I believe in 2012, and we started playing there occasionally.
How often would you play there?
Whenever he'd invite me.
And what would the cost be for you to play at that country club, if you know?
At his club, I'm not allowed to pay, so I don't know exactly what he spends on me to play golf there.
Did you ever ask him?
I don't believe we've ever had that conversation.
So he would pay for your golf because you could not pay the country club, is that correct?
Well, that, and we were friends, and I would treat him to things too, so.
Was there anything stopping you from repaying him after the golf?
I don't believe he would even accept it if I offered. So no, there was nothing physically stopping me but him.
But you did not. Is the answer no? There would be nothing to stop you from repaying him for whatever he paid for the golf?
Except for his refusal to take it.
Am I correct that you never offered it?
I don't recall whether I ever offered to pay him back. I did buy golf for him on occasion and meals when we wouldn't play at his course.
And when did you buy golf for him?
Multiple times. I don't remember the exact dates.
Would that be in a private club or in a public setting?
Public course when we would not play at his club.
And how much did you pay for his golf in the public setting?
I guess it would be anywhere from $75 around to $140, depending on where we play.
Is that, you're not aware if that amount is equal to what he paid, is that correct?
I don't know.
You're familiar with the gift ban for the county, is that correct?
I am familiar, yes.
And you included in your response to the allegations, your belief that accepting the golf from your friend was acceptable under the gift ban act, is that correct, or the gift ban clause?
Yes, I believe there's an exception for gifts from personal friends.
How long have you been aware that that was an exception?
I don't remember when I learned of the exception.
For response, you state that the ethics ordinance provides an exception to the gift ban for anything provided on the basis of a personal friendship, correct?
Correct.
Is it your understanding that as long as someone who's a friend of yours, that you could take any gift from them, even if they're a vendor?
Well, I think it depends on the circumstances. If he offered me a car the day we signed the agreement to have him provide office supplies, I don't think that would be proper for me.
But you would agree that this, him paying for your golf, that would be a gift under the, is that your understanding that it would be a gift to you?
I don't believe it qualifies as a gift under the ordinance. It's just friends paying for each other's stuff. It's what we've done for several years.
What is it about the, him providing that for you that you don't believe is a gift?
Well, because I often return the favor and buy stuff for him. So it's more of a mutual exchange.
You're not aware that what you provided him had equal value? Is that accurate?
I don't know that answer. I guess it's possible I paid more.
But you don't know that, right?
I don't.
And you never found out from him how much the golf cost at the country club?
I did not.
That would be all I would have. So obviously at this point, you know, there's going to be things you're going to want to ask the person. So probably, you know, you're going to have, like I said, you're going to funnel him through the chair and then he's going to decide if it's relevant or, you know, I mean.
One other question I have.
To the mic.
As a committee, do we have subpoena powers?
Yes.
Could we, for instance, subpoena the vendor and bring him in?
Right.
And that's, again, that would be something in a situation like this, I would probably be interested in for a number of reasons. First of all, then you could actually find out how much it cost and exactly how many times he was in there. So I thought
Likely by this point in the proceedings, I probably would have other documentary
Right.
evidence of the cost but I wouldn't, you know, if it's incumbent upon me to bring this case, I'm going to have everything, you know, that I need to prove the case. You know, nothing like this is going to come up really in a hearing that, you know, like he may not have known at the time how much he paid for the golf, but you know, I would have known it because I would have gotten that information. So that's one of the you know, the things with mock hearings that you're not going to be able to connect all the dots.
we'll try a little clarification or redirect. Clarification or redirect.
Yeah, I mean,
Yeah, normally, yes, I would have an opportunity to kind of bolster his testimony, but he did such a great job, really.
I agree.
Yeah.
The points that I would have brought out.
One of the things, and it's an interesting proposition, in this case, this is a course of conduct that has been existing for multiple years. And I think that's one issue that they've raised, and one issue that his attorney would probably focus on, the fact that this didn't occur just as a result of his employment or since his employment, but has been occurring for a number of years. Of course, one thing that changed is it went from, you know, Arrowhead to a country club in a little bit different situation. But those are kind of things that you're going to get in what is considered, it's not really cross-examination because it's his own client, but in an examination, they'll go through the past history in an attempt to show that there was a course of conduct and that there was no intent to violate the ordinance itself.
No, so I don't really, so Richard responded, you know, totally supported how this was a long-term friendship with Vinny. And I think he made it very clear to everybody that it was a long-term friendship. They had this mutual exchange. The only other thing I was going to ask about, in his letter, he said that he also would check prices online and try to show his like diligence that.
I missed that part of it.
It's okay. You did great with Vinny.
You did. I was like, ooh.
So, you know, I would probably go there, but other than that, I mean, he did such a great job, you know, establishing friendship. I don't have anything else to ask.
Okay, and just by and large, what we do is.
Closer to the mic.
By and large, what we do is a fact-finding commission is just listen to the facts themselves. To the extent there are any questions or you are not clear, you can certainly follow up with witnesses as it relates to those facts. And then once the matter has been concluded in terms of the hearing, we meet and to make a determination as to whether or not we believe the Inspector General has met his burden of proof in showing that there has been a violation of the ethics ordinance. I'm not sure whether we actually make a recommendation as to the nature of the penalty as well.
Right, I would not make any recommendation. That would all be up to you.
After you've conferred and determined liable or not liable, I think you then proceed to determine the actual sanction, punishment. And it is limited as to what you can do by ordinance.
At Part 5, authorized dispositions.
And may I ask, can the state's attorney be present with us when we are conferring with respect to
Yeah,
that?
the state's attorney will advise you on any administrative issues that, the state's attorney is your lawyer for the commission, so.
Yeah, in a situation like this where I personally would rely on the state's attorney, would go towards that. The second factor is to the nature of the discipline, any history with respect to that and things of that nature, so that we have some background. Again, these things occur extremely rarely. And so there isn't like a significant precedent for us to review. To that extent, I think to some degree, I probably would rely on the state's attorney to look at other commissions or findings throughout the state where we might be able to have at least some precedent for determining what we feel might be appropriate.
Yeah, I'm just procedurally, everybody has their own lawyer. I'm working as the prosecutor. You couldn't have a state's attorney do my job because the state's attorney can't prosecute the case and advise you. That would be a conflict. And then the respondent, if they so choose, can represent themselves or have an attorney. Part 5 of the ordinance authorizes dispositions, recommendations for discipline. When the investigator general has recommended that a complaint be resolved other than by formal complaint, or where the commission has found that a respondent has violated any provision of this ordinance, the commission may recommend to a respondent's ultimate jurisdictional authority. So you would be advising his boss as to what you would do. And you're only advising them that's what he should do. So he can take that under advisement and go with your recommendation or not.
Greg, if I'm not mistaken, though, the panel does have the ability, or the commission does have the ability to issue fines in certain circumstances,
Sure.
right? Without
Yeah,
recommendation.
then it says number 1, reprimand. Number 2, cease and desist the offensive action. 3, return of money or other items. 4, suspension. 5, donation to a charity of any of an amount equal to the prohibited gift. The imposition of fines is the next section. The commission may impose an administrative fine of up to $5,000 per violation. And that is not a recommendation. That's you imposing the fine. No ultimate jurisdictional authority of the county may waive or reduce any fine imposed under this section. So it's final word, final decision, and then that can be appealed through the administrative review process.
All right, any questions from any commissioners? Thank you very much for that. Like I've indicated, this is something that occurs very, very rarely. However, it's important for us to sort of understand the procedures and the background necessary with respect to that. The next item is new business, the fiscal year 2023 ethics training. This is one of the nicer things we get to do and has actually turned into one of the primary functions of the commission is the training that we provide to not only our county members, but I believe this goes on to Aurora as well.
So Aurora, yes, this ethics training itself doesn't go to Aurora. They have their own specific one from what I understand. Dan, is that correct?
Yeah, there's nothing online for Aurora. What we've done for Aurora is I would go over there along with the investigator general, and we would conduct training sessions in small group, basically 20 to 30 people at a time. We've never really trained every employee at Aurora, so they're all not trained in terms of taking it, but there is no, I don't think they have access to this.
No, they don't use our online site. And again, that's governed through the IGA we have with Aurora. Aurora does pay for all of that individually with those individuals. So it's not the county that bears that expense. But they are kind enough to work with us and allow that IGA to occur.
All
Okay,
right.
you want me to get into it?
Yeah, why not?
Okay, perfect. So I believe I sent out yesterday the FY22 training to everybody. So that is what we sent out last year to all the individuals that had to take it, and it is that online portion. At this time, there's 2 changes that myself and the ethics advisor have talked about and suggested that we'd like to do, and we're going to real quick tell you guys. First off, obviously change who our investigator general is. It's currently says Nancy Wolf because we haven't implemented the FY23, so we'll change that to have Greg Vasey's name. But secondary to that is on one of the review questions that talks about question number 4. Sorry, let me pull this up while I remember that. Question number 4 on here is talking about a concert pass. So we're actually talking about maybe shifting the subject a little bit to sports tickets. And the only reason this is a question like this came up this year, so we want to hit it on the head. And what it is, as long as you guys are okay with this, we'll write it up. But what the goal would be, it's just indicating along the lines of, say, a vendor said, "Oh, hey, I got 4 tickets for a game tonight." Give it to the supervisor. Says, "Hey, give it to one of your give it to some of your employees," or something like that. So that'd be the basis of the question. Essentially, is Dan, have I pretty well encompassed what we were talking about with that?
Yes.
All right, so just kind of changing the questions. The key thing is, if we keep it consistent, there's no point to that. But yes, sir.
Updating is good. Could you possibly have both concert and sporting event?
I have no.
We could certainly do that. My original goal when we got this, when we put this all together, was to try and stay on one topic and only have one question per topic, because I know it's hard to get people to take this to begin with. The longer they're sitting online, the more they zone out. So the goal was to sort of just hit the major high points. What the thought is with this particular question was, we were going to ask, did the vendor violate, and did the supervisor? And there are subparts to that question. For example, the vendor did not violate because they're not subject to the ordinance. But did the supervisor violate even though the supervisor passed those tickets on? The individuals who took those tickets violate even though the value was $75. So we can kind of hit subparts on it. So it could basically be 3 questions in one, sort of a follow-up, which is kind of what I do for the county board. I kind of when I do the live training for the county board, I do follow-up questions basically and change the scenario a little bit to get different answers.
Thank you for that clear answer.
You're welcome.
And you know, the key thing with the ethics training is, obviously we're not going to hit on every single subject or everything that can occur. However, this is a great basis. And another thing that we'll continue to reiterate in this training is, you know, if there is a question, call the ethics advisor ahead of time and say, "Hey, you know, we're looking to do this. Does this suffice?" Because then it doesn't make it to the level of the commission, which is.
And one of the other things, we all take it at some point in time.
Yeah.
So when you take it, if something pops up that you have a question on or suggestion, please feel free to let us know.
Closer to the mic. Sorry.
Thank you.
I apologize.
Pick up a little bit farther than 2 feet.
Yeah, but so that is the goal. We weren't looking to change any of the other questions. So typically it's every other year we make substantial changes. Last year we did change 3 or 4 of the questions. If I think it was 3 or 4, something like that. So this year we're just minor tweaks, and then next year we do a complete relook at it again. So that's what we've traditionally done. Now, obviously, if you guys tell me otherwise, I will do what I'm asked by the commission. But if you guys are comfortable with that, I would at least ask just for an action of saying that we are okay with the additional question in thought process, as well as approving this training to be allowed for FY23.
In effect, I would ask for a motion to approve the fiscal year 23 ethics training program. Yes.
I'd like to make a suggestion.
Sure.
Just for your consideration. In looking through the materials you provided yesterday, I jotted down on slide 4. It talks about what officers and agencies the ethics ordinance covers.
Mhm.
I'm wondering if it would be helpful to have some supplemental text talking about who is not covered. Because I think that it would be easy for someone who isn't aware to think that every elected county official is covered. And there is another place on the county ethics website where it makes clear that other elected officials have their own separate ethics ordinances. But if you aren't looking at that page, you don't know from reading this training. And I'm just wondering, I'm just raising the issue for your consideration.
Go ahead, Dan, I'll supplement.
The only problem with that is there are a lot that aren't covered.
Exactly.
So we could get into a lot of different
Yeah.
slides if we go through an exhaustive list. For example, in this building alone, there's probably 6 different offices that aren't covered by this. When we go further out on campus, it gets even more so. So it just might be too many slides if we wanted to make a list. I do get, and I'm sure Greg and Nancy used to get, Greg will get calls from individuals that will say, you know, the ex-police department's chief called me up and yelled at me. I want to file an ethics complaint, and the issue becomes immediately not subject to the ordinance. And that usually ends the conversation there, but I just don't know if there's a way to be able to give you that list in terms of manageable for an online training.
I had a county board member a few weeks ago that I just happened to see at a social setting, wanted to know about a potential ethics violation against one of the county township elected officials. And I said, I think you know the answer to that question. Yeah, I think I probably do too. But I'm wondering if maybe even just a simple statement that other elected county officials other than the county board are not covered by the ordinance. That I don't know if that would be
I think
enough.
maybe clarifying the sentence, the DuPage County Ethics Ordinance applies to the following entities in person. We can clarify by maybe saying only to these individual or only to these departments. We can just add that word in, I think,
Be good.
and we can bold only,
Mhm.
something like that. Maybe that would suffice.
I think that's a great suggestion.
Okay.
Any other comments on the training program? All right, with that suggestion as far as a modification, could I have a motion to approve the fiscal year 23 ethics training program?
I'll make a motion to approve as stated.
Second, please.
I'll second it.
Any further discussion? All those in favor, please signify by saying aye.
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 All opposed? The motion passes. Any other new business that we have to do?
Just one other thing to the ethics training. So we'll probably be getting it out end of December, early January. I think that's when Dan and I said, Dan and I work together on that. But we'll get it sent out, and then in February, we'll at least have the initial numbers of where we're at completion wise. And I'm sorry, I guess I should have pulled for this year's the final, but that's fine. We were doing very well, I can tell you that. We did a lot of follow-up this year to make sure people were taking it. But yes, so in February, we should hopefully have a report for you in regards to where we're at with the completion so far.
All right, thank you very much.
Thank you.
Any other new business for anyone? Hearing none, I'd entertain a motion to adjourn.
Make a motion to adjourn.
Second,
Second, Glennon.
all in favor?
Aye.
Motion passes. Thank you very much, everyone.